Good morning. My name is Philip Alston. I teach here at NYU and I'm chairing this panel. I will be a minimal presence, I assure you. The panel is on ratification and compliance, going to the key issue, of course, of the extent to which ratification of human rights treaties actually leads to compliance. We've got three speakers. I will introduce them only when they are ready to talk. The first paper is entitled The International Human Rights Regime, Delaying Democratization in the Worst Offenders. It's been written by James Hollier from Yale and Peter Rosendorf from NYU. Peter is going to make the presentation today. Peter teaches in the politics department here at NYU. He's previously taught at University of Southern California and Georgetown. He is very active on various editorial boards and so on, and has very wide-ranging research agenda, which seems to become increasingly oriented towards human rights type issues, which makes him a particularly apposite speaker for this morning. Peter, welcome.
Thank you so much to the chair, to the organizers, to NYU Law School. It's an absolute pleasure to be here. Thank you to Beth for an interesting book, a book that I've returned to a number of times for a number of projects. As you see, we may not agree on a variety of issues, but it should lead to some interesting questions nevertheless. This is indeed co-authored work, or based on some co-authored work with James Hollier, now at Yale University. And what we want to do is we want to explore some of the consequences of some of the observations that Beth has made in her excellent book. That the book identifies accurately, and I think in a very compelling way, that indeed the international human rights regime has been at least moderately and identifiably successful in reducing certain types of human rights abuse, certainly within the transitional states. The moderate abusers are the ones that indeed join the international institutions or sign the international agreements, and this does appear to lower abuse in those states. But there is that unexplained set that was mentioned earlier by Professor Alvarez, right? The insincere ratifiers or the false positives. It turns out that high human rights abusers join these international treaties with a higher frequency, more often. And Beth, to some degree, explains this observation by relying on, in some sense, incompleteness. That is, maybe these participants are short-sighted. They don't fully anticipate what the effects of signing the regime are actually going to be, or that they make mistakes in determining what the impact of accession might actually be, or they make errors in forms of expectations or uncertainty or information. And we take issue, I think, somewhat with this view about the insincere ratifiers, the abusers that sign and continue to abuse. And so what we want to do is to take some time to think if we can develop a more nuanced or careful theoretical understanding of the behavior of the insincere ratifiers, of the false positives. And then based on that theoretical foundation, see if indeed that theory makes predictions consistent with things that we've already observed, that we've already identified. For example, when it comes to the Convention Against Torture, it turns out that the worst authoritarian torturers are indeed more likely to sign the CAT than those that torture less. And so we'd want a model or a theory that was consistent with that observation. And we'd also like a model that is consistent with the fact that these worst autocratic torturers sign, and then they don't seem to change their behavior very much. And so we want to have a model that's consistent with that is based on rationality and individual maximizing behavior, self-interest. And then once we have such a model, we want to see what further predictions does this model make that can be tested against the available data. And in particular, we are going to state, we're going to make the claim and hopefully prove to you today that the worst human rights offenders are going to accede to a whole variety of human rights treaties more frequently, that is amongst the autocrats. that amongst these autocratic human rights abuses, treaty accession is actually going to be associated with their survival in office longer. That is, these worst type autocrats that abuse human rights do so, they accede to the treaties, and they survive in office actually longer than those that don't, and that this effect is stronger, as is the enforcement provisions of the international treaties. That is, those leaders will survive in office even longer when they sign the treaties with the most severe enforcement mechanisms. All right. So what do we know? What we do know is that the human rights offenders accede to a variety of the human rights treaties more frequently. That is, they join, and then they may continue to abuse, and that the less serious offenders exceed less frequency. And I want to show you some data that we have, or at least a picture that summarizes some of the data from some work that James Hollier and I have done that is consistent with those that have been identified by scholars like Ona Hathaway and before. What we have here is the difference in the predicted probabilities of being in each of these different torture categories. So the left-hand side there is the measures of torture scored by Ona Hathaway. And we can see that the difference between a signer and a non-signer is much likely to be higher if you are a high torturer. Okay, the predicted probabilities of actually signing the treaty will be much higher if you are a torturer than if you're a non-torturer. That is let me try that again. The difference in the probability of signing versus non-signing is much greater if you are a high torturer. So the high torturers are much more likely to sign the CAT than the non-signers. Yeah.
Peter, just a clarification. Are you talking about signing or ratifying?
These are signing.
Signing.
Yeah, exactly. All right. But in general, it doesn't make much of a difference.
For your data.
For amongst the autocrats that we look at, yeah. Yeah, amongst autocracies. All right, and the same is true when we look at a different measure of torture on the right-hand panel over there. That is indeed the difference between the likelihood of signing versus non-signing is much higher if you're a high torturer. So again, the high torturers are much more likely to sign than the non-high torturers. This is a little bit of statistics here. This is an audit probate regression that simply says what's the likelihood that you ever ratify any one of these treaties, the Genocide Convention, the ICCPR and its optional protocol, or the Convention Against Torture, as a function of how much torture you engage in. And it turns out to be the case that those that sign the CAT, for example, are significantly more likely to be higher torturers than not. Those that sign the Genocide Convention are much more significantly likely to be higher torturers than not. The effect is weaker with respect to the ICCPR and the optional protocol. So what we have here is that certainly when it comes to measures of torture, the worst offenders are more likely to sign these agreements. When we look at other measures of human rights abuse, this is the political terror scale. Again, the results are by and large, we see that the coefficients are positive, if not necessarily significant at all in most instances, showing again that the higher the degree of political repression and terror, the more likely it is that the autocrats are going to sign these conventions in the first place. All right, so this raises a number of interesting and difficult questions for those of us interested in the effectiveness of the human rights regime. Why is it that the worst offenders are going to exceed more frequently, that is sign or ratify? And the answer that I want to provide to you today is that they do so because it enhances their survival in office. All right? And if accession to the human rights treaties is enhancing leader survival, this is delaying changes in leadership and delaying changes in regime. And this is going to have significant and important implications for the effectiveness of the international human rights regime. It may indeed, as Beth shows us, improve human rights on a day-to-day basis, but it may delay regime change in those societies that might need it most. All right? And so that may be the case, and we're going to explore some of these possibilities. All right, so the conventional wisdom is that states, of course, sign treaties because they intend to comply with them. When human rights treaties are concerned, though, countries seem to sign and continue to abuse. And so why is it that an authoritarian state is going to sign one of these things and then continue to abuse human rights or fail to comply? The standard argument is, of course, that these have weak compliance mechanisms. But if that were true, then everybody would sign one of these things. And the fact is there's a nice, interesting, significant variation across autocracies about who signs and who doesn't. And we want to be able to explain that variation. There's a full game theoretic exposition in a forthcoming paper that I urge you to read, but let me give you a real sense of the intuition here. The intuition is essentially this. Consider an elite facing a domestic political opposition, and this elite has private information about the value of holding office, or at least how strongly it is willing to fight in order to hold on to that office. And if the human rights regime in any way adds to the costs of repression, for example, if the abuser is thrown out of office and then subject to criminal prosecution, either domestically or internationally, then the human rights regime does indeed add to the costs of engaging in repression. Then what we'll see is that signing a human rights treaty acts as a signal to the domestic political opposition that the leader may well be of a very tough type, the type that is not willing to give up office. All right? That is sort of willing to fight hard in order to remain in office. And what we have is a simple separation in a signaling game where the tough leaders who value office most highly, who will do anything to hold on to it, will see that there's no additional cost to signing the treaty because they will never leave office. And signing will signal their toughness. And the weaker challengers, knowing that if they may have to step down if they're challenged and may well be subject to criminal prosecution if they do leave office, face potentially much higher costs from signing and choose not to do so. And so what we have in equilibrium is the tough types sign and they continue to abuse. The domestic opposition learns that they're tough and fights, realizing that fighting hard is not doing them so much good anymore, may lower their opposition effort in response. And what we get in equilibrium is that authoritarian survivors in office will survive longer in office than observationally equivalent non-signatories. And that this effect will be larger, the larger is the effect of the enforcement provisions in these treaties. There was a nice summary of the argument on The Economist, on a blog on The Economist website. A regime that tortures its opponents and refuses to sign the CAT shows that it fears international opprobrium. A regime that tortures its opponents and blithely signs the CAT anyway shows that it fears nothing. All right? So what we have then is a model that predicts that the toughest types are the ones that are actually going to be signed, and this, of course, is consistent with some of the data that I showed you earlier on, that the toughest types are the ones that sign most frequently. But we're also going to claim that signings may enhance leader survival, and these effects are stronger as the enforcement provisions of the treaties increase. And so we want to subject these notions of leader survival to further empirical scrutiny. So we go to the data. And here's the data. This is standard data in the political science. We've got the dates. We've got torture levels in terms of CAT. We've got a lot of the data comes from Beth Simmons, for whom we're very grateful for sharing some of this with us. And what we do here is we simply look at, firstly, the Convention Against Torture alone. Now, these two curves reflect differences between those that sign the CAT and those that don't. And the vertical axis is the probability that you are removed from office, conditional on the number of years you have already been in office. And what you see here is that the signatories, the bolder black line, the one at the bottom, those signatories have a much lower probability of being removed from office, okay, than the non-signatories when it comes to the Convention Against Torture. And this diagram here uses the torture data as a control from Signorelli and Richards. In order to show that this result is not a function of the control variables we use for torture, we also use Ona Hathaway's torture measures. And we see exactly the same thing, that when it comes to the Convention Against Torture, having signed the treaty results in significantly lower probability of being removed from office, and this is amongst autocracies, than those that don't sign the treaty. All right. Well, so that we ask the question, is this just a feature of the CAT, or is this something more general? So what we do here is we take a look at the 20 most important human rights treaties, all right? And we take a look at, and we run some analysis here, and we can generate, again, a prediction about whether or not an autocrat, a dictator, will be removed from office as a consequence of having signed either none of these or half of these, based upon what we actually observe. And it turns out that if you sign none of these treaties, then we now have the solid black line, which is the black line at the top of the graph here. Conditional on having signed none of these things, the probability that you get removed from office is higher, or that the probability that you get, let me get this right. So if you do not ratify any of these things, this is leader survival. Sorry, this is leader survival. This is the probability that you survive in office, all right? If you sign half of the treaties, the probability that you are removed from office falls dramatically, once again. So signing more of the human rights treaties dramatically lowers the chance that an abusing autocrat gets removed from office. All right. Now, more complicated analysis to show that this is indeed substantiated by statistical significance, but I won't go into that. And so now I want to ask the following question. Can we be sure in any real sense that it is the human rights treaties that are causing this leader survival? What I've shown you to a significant degree is that there does appear to be a strong correlation between these two observations. And so we want to think about what might the causal mechanisms actually be. Well, there are three mechanisms or three effects that we identify. Two of them are causal, one is not. It's quite possible that two of the causal arguments don't actually apply and everything is operating through a non-causal process. All right, just to get a little technical here, the non-causal process might be that this is simply a selection effect. That the strong autocrats are the ones that would survive in office anyway, and they happen to be the ones that sign these treaties. So there's no actual causal relationship between these two things. It just happens to be that they both operate in the same direction. But there is an information effect and there is a commitment effect. The information effect is that by signing the treaty, you are signaling some information to your domestic politics. And here I'm with Beth. Domestic politics matters in understanding the effects of these treaties on outcomes. And that signing and that signaling and that communication of information to the domestic political opponents might be, I'm strong, you are not as strong, therefore, as you thought you were, you should back off. And if the opposition backs off and I'm stronger than you realize, I get to survive in office much longer. A commitment effect is once I've signed the treaties, if I do get removed from office, I am going to be punished more severely than I probably would have been otherwise. And therefore, I'm going to fight harder in order to survive in office as well after having signed the treaty. Both of these are directly causal in the sense that they could be causing increased survival in office that would not otherwise be the case. Does the human rights regime cause autocratic leader survival? There is suggestive evidence that it does. Really, the answer to that question will depend crucially on which of these effects actually dominates. And at this point, we're not quite able to fully answer the question. But I do want to raise some issues that the international lawyers amongst us might be surprised to see, which is, are the treaties there to be obeyed? And the answer is, for these guys, absolutely not. All right? That in fact, these are signed by autocrats with an explicit intention to defy. They wish to defy, they wish to be seen to be defying in order to credibly signal the strength of their commitment to holding on to office. They do so in order to signal their toughness to the domestic opposition. And this has this perhaps unanticipated consequence of the international human rights regime that these guys are surviving in office much longer than they would otherwise. Should we strengthen the international human rights regime? Should we raise post-tenure punishments? Should we make these guys more liable for criminal prosecution once they leave office? What would the effect of that be in the context of this analysis? What that would mean is that when it comes to an international treaty, and since international treaties are voluntary, by and large, countries have to accede to them, that means that fewer and fewer countries would actually be willing to accede in the first place. Those that do accede would be sending a stronger and stronger signal. They would fight harder and harder to stay in office, and that would probably have the effect of preserving the most and worst offenders in office even longer. It's not necessarily the case that more law is always better. Does the international human rights regime as we currently have it improve human rights? Well, I think that this also, to some degree, is an open question. While Beth's book makes the compelling case that indeed amongst transitional states, human rights abuses have reduced. Excuse me. It may well be the case that amongst the worst offending autocracies, these guys survive in office much longer. And the net effect may well be we might have less human rights abuse on a day-to-day basis, but the abusers are staying in office longer. The net effect, we could have more or less overall. That remains an open question and something that we will continue to study. Thanks very much.
Thank you, Peter, for those very stimulating and provocative remarks. I wish this conference was better organized, and we would be able to say that we'll now go to a video link with Muammar Gaddafi and ask him if, in fact, he ratified the various conventions with your thoughts in mind. But unfortunately, we haven't been able to set that up yet. The second speaker then is Professor Joel Trachtman, whose paper is entitled "Who Cares About International Human Rights?" How did I find myself up on a panel with this bunch of skeptics? There's got to be some mistake. The demand for and supply of international human rights law. Joel Trachtman teaches at the Fletcher School of Law and Diplomacy at Tufts University. A former colleague of mine, I'm very happy to say, has written prolifically in a wide range of fields, but particularly applying economic perspectives to trying to better understand how law really functions. And it's wonderful to see him applying those particular skills to the human rights area. Welcome, Joel.
Well, thank you, Philip. And it's really a pleasure for me to join in this wonderful conference honoring Beth Simmons' book, Mobilizing for Human Rights. I have two prefatory remarks I want to make about my presentation. And I meant the question, who cares about human rights, to be an inquiry about the level of care. But the prefatory remarks are, as Philip has said, my principal area of study is international economic law, and I come as really a stranger to human rights law, and especially to the empirical study of the effects and the causes of human rights law. And the second prefatory remark is partly because of my background in international economic law. I come with a bias towards seeing international law in contractual terms as opposed to in expressive terms. And I recognize that the expressive understanding of international law has power, but in my remarks about the supply and demand for human rights law, I'll focus more on this question of how are these things understood contractually. And what I will try to do is attempt to contextualize and interrelate some of the causal factors, or at least suggest a context and a relationship among some of the causal factors that the literature highlights. But I think coming from international economic law and even coming from other areas of international law, one would say that the field of human rights law is different. It's different in that we don't really have in-kind, very narrow reciprocity, or at least I don't appreciate it that way. Instead, we have truly asymmetrical law where there are what I would call, let me see if I can move along here, what I would call good guy states and bad guy states. And the international law seems designed to affect the behavior of bad guy states. So good guy states I define as those with sufficient autonomous desire in their domestic politics to protect human rights. And for them, international human rights law wouldn't have any effect or any depth. Thank you, Amanda. And second, for bad guy states, those are the ones who in their domestic political equilibrium have an insufficient desire to protect human rights law. And then the question for them is, why would they commit? And this is a question that Peter raised in terms of time and consistency. Why would they commit ex ante to something that causes them to do what they would rather not do in their domestic political equilibrium? So this, for me, yields four types of questions, really about demand and supply, about the relationship between what I've called good guy states and bad guy states. First, why do good guy states care about human rights and bad guy states? And that relates to both the accession to a treaty and the subsequent compliance with the treaty. Second, about bad guy states providing the supply in terms of accession, what incentives would induce them to adhere to human rights treaties that cause them to do what, by definition, according to my definition, they are not autonomously inclined to do? Third, and something I won't speak much about, is what causes the supply of compliance. This is a critical concern of Mobilizing for Human Rights and of much of the literature here, but to save some time and because I don't have too much to say about it, I won't highlight that. And then fourth, how do we develop a relationship between supply and demand? In a price theory sense, what's the magnitude of the demand by the good guy states for human rights and bad guy states, and what is the cost, what's the magnitude of supply, the net cost, I should say, of human rights adherence and compliance by bad guy states. And in addition to that, we have a group of good guy states, and as Eric Posner has pointed out in a 2010 article, there might be a public good or collective action problem among those good guy states in terms of determining who makes the payment to induce the bad guy states to adhere or comply with human rights. So why is demand important? I think, and again, demand is demand by good guy states for human rights adherence or compliance in bad guy states. If there were no demand, I think there would be no supply of international law because no one would be willing to pay anything for international law. Again, this is a contractual perspective as opposed to an expressive perspective. Second, even lock-in theories of the kind developed by Andy Moravcik have trouble responding, I think, to this question of what would be the purpose of international human rights law if the good guy states didn't care. Because for international law to work, to lock in domestic reforms, foreign states, the good guy states, have to care enough to bring that international law to bear at some level. So I do think that the acculturation theories also have trouble explaining the role of binding international law. This is the question that Rob House asked earlier. What is the differential, the special role of binding international law in this context? So I think it's better to understand acculturation, sociological theories, constructivist theories, as addressing the supply side, as reducing the costs to bad guy states of accepting human rights commitments. So turning to this question of demand, in the literature, there seem to be a number of different sources of demand. One quick one, and maybe the leading one, is physical externalities, refugee problems, wars, other problems that can hurt good guy states. It's a reason why good guy states care. Second, and we see this in yesterday's congressional approval of the of the free trade agreement between the United States and Colombia, there might be pecuniary externalities, competitive externalities, where labor groups fear a competitive race to the bottom in their rights and demand that, in that case, Colombia respect certain levels both of the content and of enforcement of human rights as a condition for a free trade agreement. Third, and maybe the most powerful beyond even physical externalities, is altruistic externalities. We care because we are human beings and we care about what happens in other places. And this may be accentuated by globalization, modern media, etc. Fourth, and probably a modest factor, is global public goods. Human rights do seem to contribute to wealth and to the ability to engage in commerce, and that can improve the situation of others. So that's a possible mechanism, a possible reason for good guy states to care. And last, and one that is interesting in perhaps smaller groupings like the European Union, is the possibility of actual mobility. An Italian person might actually travel to France and so might care and migrate to France and live there and so might care about human rights there or might be an investor. So those are some of the ideas that we see about possible sources of demand. And as I say, it's important because without demand, it's hard to understand, at least from a contractual perspective, why international law would exist. Second, what induces bad guys to accede to these treaties? And as I say, my only concern is with bad guys. If they've been acculturated and have developed, as Beth suggests is an important factor in her book, a respect for the principles of human rights, and if that respect is sufficient for them autonomously to respect human rights, I'm not really interested in their accession. I think it's inframarginal. It's not social scientifically very interesting if they already are autonomously inclined to respect human rights. We might have lock-in questions, concerns about the future that may motivate them, but putting that aside for a moment. And so the question for those bad guy states is are the benefits of accession greater than the costs? And the costs, we know from the literature, include, and it's obvious, include loss of autonomy, perhaps regime stability, although Peter's argument suggests the opposite in some cases, administrative costs, and as I said, acculturation might reduce those costs and might indeed induce a greater proclivity to enter into these treaties when the cost is reduced because the bad guy state has become less bad. Its preferences are now more oriented towards human rights. So what are the benefits? And here I turn from this contractual perspective to a focus on reciprocity, reputation, avoidance of retaliation. Again, this is dependent on demand. It's dependent on the behavior of the good guy states. And we see possibilities in that Colombia Free Trade Agreement, for example, of linkage as a way of providing benefits. You could have direct payments. In fact, foreign aid in some cases might well be understood as a direct payment for adherence or for compliance. And indeed, in a paper with Nielsen, Beth does develop some evidence about the extent to which certain benefits provided by wealthy states might be related to accession. I'll let that paper speak for itself, but one might appreciate some of the evidence that Beth brings to bear there as suggesting that there are circumstances where good guy states actually are willing to pay money or to provide benefits in exchange for accession. We have reputational and signaling types of arguments, and here the paper by James Hollier and Peter Rosendorf, it kind of turns the typical signaling approach on its head. They're focusing, as I do, on demand as well as supply. The question that I would ask is, to what extent is the effect that you're seeing of harsher torturers acceding to conventions being caused, how do we know that it's not being caused by the demand of good guy states? They see more intense torture and they say, those are the states we want to target with our incentives or our retaliation. Another benefit of accession, and this is more on the autonomous side, is the lock-in effect. And there, to have that lock-in effect, we would have to have some quasi-constitutional power of international law. And that would be dependent on an understanding of the power of international law compared to ordinary domestic law or domestic constitutional law. There, I think also that modern behavioral economics would suggest that there's really something to that lock-in idea, that according to the work of Richard Thaler and Cass Sunstein, the Nudge book, there are times when we use law or rules to lock in something that we would do in a reflective state and avoid doing something in an automatic state. So it may be that that's part of the autonomous benefit of accession. But I think, as Peter suggested, there are some time inconsistency problems in this literature. So where accession adds to the net costs of violation, it's not possible to me to explain accession of bad guy states except by reference to benefits of bad guy states. I don't think it's proper, without really evidence, to assume that they're making a mistake. Why are they engaging in that type of mistaken behavior? And so again, it's hard for me, if we're working with bad guy states, to say that accession is caused by because of agreement with the principles of human rights law. Why are they, if they're truly, according to my definition of bad guy state, why are they entering into that treaty that hurts them? And this applies to work by Hafner and Tsutsi, who see cynical signing combined with compliance combined with subsequent compliance due to a legitimacy push. And there again, the question is, why do bad guy states make mistakes? So thinking about the supply of, I'm running out of time, so let me skip over compliance and go to the question, which I think is the essential question, of where do supply and demand meet? Where do we get the production of international human rights law? And I think it's important to recognize that demand and supply interact through a kind of price mechanism, an implicit price mechanism. And the cost to bad guy states affects the supply. And so we can look at acculturation, we can look at lock-in and say those things reduce costs, and they are likely to result in greater supply. But supply in itself is not sufficient to cause international law. We have to have demand. We have to have two parties to this contractual bargain. And we can measure demand by looking at some of those factors that I described. And as I said in my question about Peter's paper, it is possible that the violations, those very torture instances that make a state a real bad guy, might be exactly what's causing the good guy state to make demands. And I think as Beth's work and Andy's work and others in the political science area have shown, we have to look inside domestic politics to understand what's going on. So I tried to describe a preferential trade agreement and human rights example to highlight the role of linkage and reciprocity. And this is really supportive of the point that Catherine McKinnon made on the first panel, that that international law can actually change the political equilibrium of target states. And this is an example of how. And you can think about the Colombia Free Trade Agreement in this context. So you have a bad guy state that's really interested in a preferential trade agreement, but has weak support for human rights. It's a bad guy state. But then you have a partner good guy state that has strong support for human rights and weak support for a preferential trade agreement. But through reciprocity and linkage, they can both get more of what they want. Both of their political elites can satisfy their domestic constituents more and get more political support by entering into an international legal agreement. And in this particular instance, the bad guy state that has strong support for preferential trade agreements can use that support to suppress opposition to human rights, while the good guy state with strong support for human rights can use that to suppress opposition to the preferential trade agreement. So then finally, as Eric Posner has pointed out, there's a cooperation problem. If you've got compensation by good guy states, who's going to provide the compensation? Won't there be an incentive to free ride on the payment of others? And that's definitely an issue, but it's one that might be resolved by coordinated entry into multilateral human rights agreements and perhaps by having minimum numbers for entry into force. And then we have the question separately from that, do good guy states work together? Some work by Mascarenhas and Todd Sandler has shown that they don't generally in aid, but there are some multilateral institutions like the World Bank where they might actually have tools for working together. So, conclusion. It seems to me, based on this review of the literature, that the international law of human rights will often still require reciprocity, reputation, and retaliation as mechanisms to induce bad guy states to enter into treaties. Reciprocity of various kinds is something that induces demand, that induces good guy states to care. The role of international law here is to cause domestic political equilibria that would not otherwise prevail. Therefore, and this is in response to Andy Moravcik's comment from the floor, what is the counterfactual? The counterfactual is a different domestic political equilibrium. Therefore, international law has no purpose if there's powerful agreement with the principle sufficient to cause autonomous protection of human rights, except in a lock-in theory to control subsequent politics. Demand interacts with supply through a price mechanism, and the public good problem is significant and could require coordination among good guy states. So the idealistic note with which I'd like to end, or the perhaps optimistic note, is that international law can turn bad guy states into good guy states through reciprocity and linkage. The concern is that this whole mechanism could operate the other way to induce good guy states to be bad guy states, but there may be reasons why we don't do that. Thank you.
Thank you very much, Joel. You turned out to be a good guy after all. The final speaker on this panel then is Andrew Moravcik. Andy teaches at Princeton, professor of politics, director of the European Union program there, has written, again, very extensively across a wide range of areas, but certainly in the human rights area is particularly well known for his seminal analysis of why states ratified the European Convention on Human Rights. Andy, welcome.
I'm going to try to move this.
Crash the system.
There we go. There we go. So Catherine McKinnon was right to laud the virtues of Beth's book. The care, the precision, the rigor, and particularly the self-discipline not to overstate empirical results. And those of us who do empirical work, think of ourselves as empirical people, particularly appreciate that because it's extremely rare in this and all social scientific professions. Still here, what I want to do is ask where this book fits in the big picture of international relations and international law scholarship, more like the questions we were asking on the first panel. And two questions in particular. First, in what ways what Beth finds is consistent with the broader literature that we have today on international law and human rights? And secondly, how distinctive the area of human rights is as compared to other issue areas in international law. And I asked the second question because legal processes in international law and in human rights and human rights generally is often treated as if it were very unique, perhaps because the motivations are idealistic on the part of some actors or non-material on the part of some actors in that issue area, perhaps because of the distinctive role played by vertical enforcement, that is, by embedding enforcement in domestic institutions or domestic norms in society, rather than the classic horizontal compliance mechanisms. But as Jose Alvarez pointed out, this has real implications if you're a theorist of international law. If you're a realist, an old-fashioned realist, you might think this just shows that human rights must be an area in which nothing important happens as a result of treaties. And if you're a constructivist, you might think it's an area in which really special things happen that are different than in other areas. And I think this kind of subtle form of human rights exceptionalism can obscure, as much as it reveals, that the kind of distinctive empirical dynamics that Beth has revealed in the book confirm regularities that scholars have found elsewhere in international relations and international law and are worth looking at. Specifically, we shouldn't underestimate the extent to which other issue areas also involve value commitments and also involve vertical enforcement in very effective ways. Secondly, that we shouldn't underestimate the extent to which human rights often involves horizontal, as we just heard, horizontal reciprocity-based enforcement, which continues to play a role even in this area. And in both these ways, despite some particularities, human rights actually looks more like areas like trade or non-proliferation or European integration than you might think. And Jose is also right that all this builds on a liberal tradition of international relations and international law thinking that examines how individuals and groups in civil society strategically employ international commitments to further their own interests in domestic and transnational society with regard to the regulation of interdependence. And according to liberals, what shapes how they do this are material interests, views about legitimate public goods provisions, and the nature of the representative institutions that decide which of those groups are going to be influential. Social groups seek to manage interdependence, and every state represents some subset. And the question is really who gets represented and what do they want? Now, this sounds very vague, but when you get down to the applied theoretical level, in fact, the kind of theories that come out of it, ranging from endogenous tariff theory to democratic peace theory, to the kind of theories that Beth develops in the book about human rights and Joel laid out, tend to be relatively specific and quite powerful. And you can see in the sort of arguments that Beth makes that, in fact, this is exactly the kind of process that goes on, that international commitments trigger changes in national interest, that compliance is a function of the way treaties shift domestic institutional opportunities, influence, and idea, and strategic calculations by domestic groups. So I'll suggest 6 empirical and theoretical propositions that one might draw from this book, Mobilizing for Rights, and place them in the context of existing IRIL work. And they suggest the general approach that she's taken applies more broadly, resonates elsewhere, and could be extended or modified looking at other issues such as trade, European integration, and non-proliferation. So the first conclusion, which is a little different in tone, it's the same conclusion but turned on its head in a sense, is that most state behavior in human rights, and by state behavior we mean acceptance and compliance with legal norms. Most state behavior in human rights, as in trade, European integration, everything else, is demand-driven and exogenous to international institutions and legal commitments. It's driven by baseline variables, variations in underlying state preferences across states of the world, which derive from the functional economic interdependence, cross-national variation and views that states have about what they want in the world. So Simmons' purpose in the book is to show that human rights treaties matter. And as we discussed before, the great thing about this is she does so by first controlling for the other factors that might lead states to want to act in a more human rights regarding or human rights violating manner. And of course, this provides her with the opportunity of illuminating that wedge of behavior that treaties influence. But it also reveals that most of the variation in whether or not states are human rights regarding or not is driven by underlying domestic transnational variables that don't have to do with treaties. It's a relatively small sliver. And this is perhaps the most striking finding in Mobilizing for Human Rights, that in the broader scheme of things, treaties are not the most important factor. Why? Well, first of all, because states contract into legal regimes. So Simmons' analysis is very careful to be a two-stage analysis where we first look at why states contract or don't into various regimes. And that the reasons they contract tend to have to do with things like regime type and NGOs and values and whatnot. And if we look at case studies of when these regimes expand, we see them expanding after World War II. We see them expanding at times of waves of democratization, moments where communism falls, things like that. Even once we are within a regime, the effect she ultimately finds is moderate in size, and as many of us have mentioned, largely limited to certain issue areas and transitional states. So there's no disagreement, really, that the exogenous control variables, which Beth so carefully lays out, are doing most of the work in explaining variation. And this is exactly what we should see, because it's exactly what we see in most areas of international relations. The structure of policy interdependence between states, the nature of appropriate domestic conceptions of regulation in different states, their values, and domestic representative institutions drive most of the big picture variation in what states want or do. And we see this also in international law. So if you look, for example, at the work of Charlotte Koo about the changing substantive content of international law over the long term, over the last 200-300 years, you see a shift from military agreements, then with the rise of the trading state, more economic agreements, and then a sliver more recently to human security and human rights agreements more recently, tracking these shifting concerns of states at home and their shifting values and interests. In trade, we see a shift in trade regimes, the purposes of trade regimes, the location of trade regimes, with the great North-North trade boom and the move away from empires and North-South trade after the Second World War, much of which predates the creation of those trade regimes. This is particularly clear in the case of the EU, where most of the movement of trade between European states actually takes place before the European Union liberalizes trade. And gravity models show that 85% of European trade can be explained by a pure gravity model, leaving only 15% to be explained by the policy changes. So that gives you some sense about how much work the underlying variables are doing and how much work the policy variables are doing. Even in security areas such as the NPT, what you've seen in the literature over the past decade or so is much more attention to demand-side theories of why states seek nuclear weapons, why they accept constraints on trafficking in nuclear materials, or are willing to accept various provisions of the nuclear agreements. Again, driven largely by interdependence concerns, economic concerns, particular security conflicts having to do with values. So again, most of the variation is exogenous, and this is consistent with literature across a wide range of issue areas. Second point, international law tends to rest on coalitions, domestic coalitions in every member country, and these comprise both direct and indirect beneficiaries of policy coordination. This is a point that Joel Trackman has stressed in some of his work. Direct beneficiaries who benefit from changing their own country's policy, and indirect beneficiaries who benefit from changing other countries' policies. And often they form coalitions together and thereby strengthen support for international law. So this is most obvious in trade, where importers and consumers who benefit directly from liberalization of trade form coalitions with exporters who benefit from shifting policy in foreign countries to form a free trade coalition. And it is striking that in most areas we see a coalition that comprises both. I'm quite grateful to Joel for laying out some of these horizontal reasons very clearly just now why human rights also fits into this paradigm. We often think of human rights, and I think Joel was actually making both sides of the argument in a way in his talk, as good states imposing on bad states a particular view of the world. But there are, in fact, lots of reasons, particularly within the best functioning legal regimes in human rights, like the European Convention on Human Rights, why countries have horizontal, collective, reciprocal reasons why they want to be in these regimes. They were originally created as bulwarks against totalitarianism, fascism, and communism, which was something that almost all member states were concerned about, either directly or as a function of externalities. In the 1990s, they were interested in, again, both for self-interested and externalities reasons, socializing the post-communist states and imposed Protocol 11, which made individual petition mandatory for that reason. The European Convention on Human Rights now functions essentially as a collective pact for which there are strong constituencies in every state to correct the flaws in democracy in each nation. For example, why did the UK incorporate the European Convention on Human Rights in 1997 when the Labour government under Tony Blair came in? For self-interested reasons, this was a government that came in and said, we will domestically and internationally do everything we can to strengthen human rights enforcement. And also for altruistic reasons, as Catherine Sekink and others have laid out more clearly than I could here. And this is, again, very much like what we see in other issue areas such as trade, where countries combine an interest in free trade to implement domestic reform, as in Mexican entry into NAFTA, so it's argued, or Chinese entry into the WTO, or Republican support for free trade in the United States, and interest of exporters in reaching foreign markets. So again, human rights looks a lot like other issue areas. Third point, compliance is induced not simply through horizontal reciprocity, but through vertical enforcement embedded in domestic interests, institutions, and ideas. Now, often this is seen as something that's somehow distinctive to human rights as an area, this form of vertical embedded enforcement. But of course, this has been the core argument of many liberal theorists of international law, that most international regimes are primarily based on vertical, not horizontal, enforcement. Most international legal instruments are implemented domestically as well as internationally. And perhaps the most striking example of this in trade is the European Union, because the European Union doesn't just not have provisions, as does the WTO, for dispute settlement in the state-to-state sense, or for structuring reciprocity or retaliation. But in fact, it bans all those things. So it makes it more difficult to engage in horizontal enforcement of the trade agreements, basic trade agreements of the European Union. The only way to enforce the European Union rules is through vertical enforcement. And yet this regime works fine. So if you were inclined to think, as I think many of us are, that the fact that human rights is somehow not as reciprocal fundamentally as an issue like trade, and therefore is less likely to have horizontal enforcement, and that's why it has vertical enforcement. In fact, there doesn't seem to be a clear correlation between a reciprocal structure of interests and a reciprocal structure of enforcement. These two things are separate, and you can have a reciprocal structure of interests in trade and a vertical enforcement system, as the EU shows. Fourth point, a complete theoretical account of vertical compliance mechanisms and endogenous change over time, which was Rob House's point earlier, must take fuller account of a wide range of factors which affect how preferences emerge from state-society relations, including economic interests, legitimate conceptions of public goods provision, and domestic representation. This is where I think the true promise of Beth's agenda lies, because she sets forth three mechanisms: elite, attention, mass mobilization, and judicial litigation. But there are, in fact, many ways domestically that you can seek to embed international law into domestic life, many of which have been worked out within other strands of literature. So, for example, in the trade literature, there's a wide literature of Goldstein and Weingast come to mind about the way in which international institutions induce changes in firm behavior, such as that it creates self-fulfilling prophecies in trade. You've got an extensive literature in the European Union about the details of the ways in which you can embed judicial and regulatory networks into national governments. So in fact, there is a wide range of theoretical mechanisms that we could be looking at here. These three seem to be a rather arbitrarily small set, and this is where we really should be looking in a broader framework. Fifth point, under what institutional conditions do these vertical mechanisms work best? So suppose we are thinking about implementing vertical mechanisms, and now we realize they could be used almost anywhere. What do we know about when they might work best? All right, well, the liberal IRIL literatures looked at this question somewhat, and their argument, although it seems like a kind of a crude first cut, is that the dynamism and effectiveness of an international legal enforcement system that's based on this vertical embeddedness in domestic politics is a function of the breadth of access to that system, the national adherence to a global rule of law in adjudicating disputes, and domestic incentives to enforce. So you can think of it as a kind of life cycle model of adjudicating something. You need to have access, you need to have some independent, sympathetic adjudicator, and you need to somehow implement it. The access point is perhaps the most striking one, and the one that resonates most with Beth's work. If you look at different tribunals and you simply ask how broad is their access, how many of them have individual petition for single individuals, and how many cases do they get, the differences are measured in orders of magnitude. So if you look at institutions like the EU or the European Convention on Human Rights, they have something on the order of 1,000 times more cases in their docket, perhaps now getting close to 10,000 times more cases in their docket than do institutions like the International Court of Justice, where only states can bring cases. So the dynamism, the fundamental dynamism of a legal system is a function, above all, no matter what the issue area, of the source of its cases and how many it can get. And then there's the question of the independence of those who adjudicate. Here, there seems to be kind of a curvilinear shape of sorts, that among countries that have no independent judiciary or rule of law, then it's hard to have domestic courts that decide in favor of litigants, and it gets the state. But oddly enough, in countries like the United States and Germany, where you have a very, very robust tradition of the independence of the judiciary, literature seems to suggest that courts are also very careful to defend their prerogatives. So the German government courts, despite their reputation, have been actually kind of skittish about European Union and European Convention on Human Rights ceding prerogatives to the European Convention and European Union. And finally, implementation, and this brings me to the final point, which is we should have limited expectations about what these kinds of regimes can achieve. The striking finding of Simmons' work, which Peter Rosendorf just recently, Peter Rosendorf's paper strongly underscores, is that these kinds of regimes can only provide a limited amount of forward momentum for any kind of substantive goal. So if we ask ourselves the sixth and final question, under what substantive conditions do regimes change behavior? Existing research seems to confirm a kind of universal U-shaped or inverted U-shaped result. Rather than there being a kind of good guy state and a bad guy state, the world seems to consist of good guy states who remain relatively unaffected, only on the margin, and bad guy states who ignore it, and transitional states in the middle who are the ones who are most affected. In this, Simmons confirms what Ona Hathaway, although she was broadly skeptical, actually, if you look very closely, she also finds some effect there. Anne-Marie Slaughter, Larry Halfer, myself, and others found that transitional states seem to be where the action is. And it is consistently true that human rights regimes, particularly the legal ones, have a great deal of trouble dealing with mass atrocities. Even the European Convention system was helpless when dealing with Greece and cases like that. Even persistent violators, like Russia today, cause real problems for a system like that. Now almost half the ECHR docket comes from 4 or 5 countries, and they're starting to lose their reputation for being a system which generates high levels of compliance. You get perverse effects, as Peter Rosenberg pointed out, and Andreas von Staden has recently pointed out that governments can tailor their implementation strategies to the cost of implementing a judgment. So if the judgment is very costly to them, hits a sensitive national interest, they will implement it very narrowly. If it is costless, they'll implement it very broadly. All these things suggest that there are limits on the extent to which you can impose change from the outside. And this dovetails with what we see in the NPT, where you have nuclear weapons states which don't change, and incorrigible states like Iran and North Korea which don't change, and the regime really affects the states in the middle. And I think there's probably a parallel to trade, but I'll leave it to Rob House to figure that out. So in conclusion, if you believe that most international legal norms are largely consensual across states based on exogenous convergence of interest, and then they work through these domestic mechanisms that are very subtle, that involve co-opting groups, changing institutions, focal points, and so on, then it follows that international law will be largely about dealing with exceptions, with transitions, with the slivers on the margin, with cases that are more controversial domestically than internationally, because you need an international consensus to get the system going. Given this, given all that, it's striking that Beth found statistically as much as she found. You would have thought that you would find a lot of stories about human rights, cases like don't ask, don't tell being imposed on the British military. So if you're gay and you're in the British military, it's a good thing, but they don't show up in the statistics because you wouldn't get a big enough aggregate effect across the board for that really to work. I think it's a very optimistic finding that there is, at least in some places, enough heft to all these different factors taken together that they show up in this kind of aggregate statistical work. And so it's now incumbent on us to really take apart those mechanisms and figure out what's going on. Thank you very much.
Thanks, Andy. We have about 10 minutes left, which I guess gives us time for some questions, if not too many answers. But if there are any questions, perhaps we'll take several first and then see what we can do. Yes, there's a question there.
I have a question for Professor Trackman. I know your study focuses on the state-to-state relationship in more contractual bargains, but I was wondering how about private actors? such as NGOs and entrepreneurs, where do they fit into your theory, and do they matter? And if they do, what would that affect your conclusions?
Yes, why don't you answer, Joel?
Well, thank you for that question. I think you're quite right, and Beth Simmons' book and Professor Moravcik's remarks support the idea that we have an important role for domestic public policy entrepreneurs and domestic litigation, and that's the mechanism, as Mobilizing for Human Rights shows, a leading mechanism for implementation of human rights. The question that I've been asking is, what is the relationship between international law and those activities? And Professor Moravcik focused on that. And so what I wonder about, and I'm just repeating your question in a sense, is what is the differential impact of having international law that repeats what is already in domestic law, or does it change domestic law? And if it changes domestic law, then the first impact is on the domestic legislative process. And to me, I think it is quite important that international law can call for, and this U.S.-Colombia Free Trade Agreement directly does, changes in domestic legislation, which can then be used by these litigants and public policy entrepreneurs to promote what they're interested in. So there's definitely a combined set. It's a combined effect. Is really all that I can say. Thank you.
There's a question from one B. Simmons.
Predictably, I have to push back a little bit against Peter. So here are my questions. First of all, I guess the first one's just an observation, and that is that the international human rights regime as a whole would have to be tremendously legitimate internationally for any of his theory to hold. You understand that it involves defying an international regime which raises costs. So that is all to the good, because for any of that to work, the legitimacy of the regime has to be huge. The second thing that I just want to push back against just a little bit is the claim that among authoritarian states, those that sign the Torture Convention are worse torturers. And so I just opened up my Stata and had a look. And if you look for the year 2000, and you just use the countries that are never democratic any time during the post-World War II system, using Anne Hathaway's data, the difference on average for just this slice of time, and I'm not saying I'm using the exact same countries or the exact same years you may be using, but the difference is the difference between 1.66 and 1.76 on that scale that he's using. And I just don't see the big difference. It's a 5-point scale. Okay, so it's not, point is, not much difference, really. And the big difference is between the oppressive and the non-oppressive. On average, these countries are all bad, and there's not much difference between how bad they really are. The next thing I wanted to just point out is that if a treaty raises the cost of torturing, and this signals their toughness, it raises some issues. It strikes me that, first of all, this is not something the opposition would not have realized from the beginning, that they were probably facing a tough government, one who already engages in a huge amount of torture. That knowledge cannot have been missing from the opposition before a government ratified a treaty. And it raises the question of why sign a treaty. Would this make the point clearer than it would have been in the absence of the treaty, that you are facing a tough government? And you know, if you really wanted to make your point most clearly, then take some of your opposition out to a press conference and shoot them at the end of it. It strikes me that signing a treaty is not the clearest way to express a message of toughness. Now, another thing that strikes me as inconsistent with the observation that governments, even bad ones, you're sort of using the treaty in this way, is that they deny they torture. Now, if they really wanted to send a clear signal, governments would be bragging they torture. To my knowledge, this is not the case in the sort of generally and especially among the countries. Almost all deny that they torture. And then finally, one of the interesting things about the picture shown of the sort of, the two curves about sort of lasting in office between whether you've signed and whether you have not, it doesn't tell us how many data points are out there in the 30-year range. Okay, that's the part where you see this big divergence between the ratifiers and the non-ratifiers, but how many countries are out there in the 30-year range driving these results? And it's probably a very small number of countries. In fact, one of the things I found when I looked at governments, I should say, how many governments last 30 to 40 years, and that would be driving that result out in the tail of the distribution, okay? Now, the other thing I just wanted to ask, I guess, is to inquire about sort of when governments are ratifying these conventions, because one of the things I found when I looked at autocratic regimes is that many of them, and I didn't look at the CAT in this context, but I looked at the International Covenant on Civil and Political Rights. The more autocratic the regime, the later they are to ratify in their time in office. And I just wonder whether you're picking this up, because my argument is really about autocratic governments often ratify these agreements when they have short time horizons, when they're just about to the end of their stay in office. It's no accident or mistake, I think, to wonder why Pinochet ratified the Convention Against Torture 6 months before an election. Sort of short time horizons, roll the dice, take a gamble. And so I'm wondering if some of these long tails are really that the conventions were ratified already close to the tail, and not the convention caused the tail to go up.
Okay, thanks, Beth. We actually have no time left, but it would be unfair. It would be unfair not to give Peter the opportunity to withdraw his thesis and apologise.
Well, Beth's given me 6 points to rebut. I'm not going to possibly be able to do that in the time that's available to me. Let's just say that there is a clear and statistically significant difference between the amount of torture that the autocrats do that sign against the ones that don't. So that is an indisputable fact. Whether it's large in terms of the actual differences in amount of torture, well, I think that those scales are very poor. These are 3-point scales or 5-point scales. So some small difference between the average of the signers and the non-signers could still be a significant difference in the amount of torturing that goes on. Do these autocrats need to sign treaties in order to signal their toughness? I am absolutely sure that there are all sorts of ways these guys could signal their toughness. And no doubt being abusive of human rights is definitely one way in which they do that. I'm not for a moment suggesting that the international human rights regime is the only way they can go out and signal toughness. All I'm pointing to is a possible unintended consequence of the regime as it possibly stands that hasn't perhaps been fully anticipated or understood. As to what's going on at the end of the range, yeah, there's no question that all sorts of funny stuff is happening towards the end of the distribution, but most of our observations lie in the early areas, in the early parts of those graphs, and that the strong and distinct difference between the leader survival times of the signers at early parts of their tenure is very, very robust as well. And so it's not being driven by necessarily what's going on at the end of the end of those periods. And I would encourage you, if you don't like that, just to ignore. Put your hand over that part of the graph, exactly. There's plenty more that I can talk about, and I'm happy to engage anybody who wants to chat about this later, but I think we have indeed run out of our time. Thank you all so much for your attention, your comments.